Welcome to this third session of our workshop on the Gabčíkova-Nagimaros judgment and its contribution to the development of international law. I warmly thank, and I'm very sincere in doing that, I warmly thank Serena and Makan for their kind invitation. I confess that I accepted simply because for my vanity, and now I'm very ashamed to be sitting here between or nearby two experts of the law of treaties. As you know, I'm particularly interested in this topic because it environmental aspects. So it will be a privilege to listen, to hear from you some inspiring considerations on interpretation and termination of treaties. Flexibility versus stability, or stability versus flexibility. This is a problem that can be approached, that can be dealt with in the perspective both of interpretation, treaty interpretation, and termination of treaties. But there is also another tension, that is pacta sunt servanda versus in ad implenti non est ad implendum, or a rebus sixtantibus situation. I don't know how far the International Court of Justice in this situation supported a flexible approach to interpretation, but I invite Ilaria to take, Irene to take the floor, and I also remind you that Irene is the youngest speaker of our workshop, but I am sure I've seen her abstract, and it is a very good contribution, so we all support you.
Thank you very much. Thank you very much, Professor Pineschi, and thank you also to Serena and Makan for this huge opportunity. I believe that the main contribution given by the Gabčíkova-Nagimaros case to the development of international law as regards the interpretation of treaties concerns the evolutionary treaty interpretation. In particular, I believe that in this case, the court crystallized or consolidated the idea pursuant to which evolutionary treaty interpretation is nothing more than the result that can be reached by application of the methods laid down under Article 31 of the Vienna Convention of the Law of Treaties, considered as a whole and by taking into account the equal basis. In the first part of my presentation, I will show how this can be inferred from the judgment, and then I will turn to case law of arbitral tribunals and international courts in order to demonstrate that actually, after Gabčíkova-Nagimaros, the approach taken to treaty evolutionary interpretation has been exactly the one purported by the ICJ in the Gabčíkova-Nagimaros case in the last 20 years. In the judgment, the court perceives the text as the starting point. It starts from the wording of the treaty, the 1977 treaty. And in particular, the court clearly affirms that as regards the wording, the treaty used general and therefore vague terms that clearly expressed the will of the parties to, the objective will of the parties to accommodate change. This solution has been also supported by referring to the other methods laid down under Article 31. The terms of the treaty were placed into the context, the internal context, the context within the treaty, and the external context as well, by referring to the related instruments of the treaty. The solution had been reached also by making reference to the object and purpose of the treaty, and as we have seen yesterday, this treaty was to serve several purposes, among which there was also the protection of the environment. Furthermore, the court also refers to the subsequent positions of the parties in order to conclude for the negotiability of the treaty terms. And in the end, it also refers to the principle of systemic integration in order to make clear that the new development in the field of environmental law were taken into account. As regards this implicit reference to Article 31(3)(c), because I have to say that the court does not specifically refer to Article 31 of the Vienna Convention, and that the Vienna Convention was only applicable qua customary law to the case at hand. And notwithstanding this, I clearly believe that behind the reasoning there's Article 31 of the Vienna Convention, and I also clearly find reference to the second part of the intertemporal principle stated by Judge Huber in the Island of Palma case, when the court says that what might have been a correct application of the law in 1989 or 1992, if the case had been before the court then, could be a miscarriage of justice if prescribed in 1997. What I argue is that after this judgment, and because or thanks to this judgment, afterwards in the last 20 years, actually practice of international courts and tribunals showed that this was the correct approach to evolutionary treaty interpretation. Evolutionary treaty interpretation is not a method, but it's the result of the application of the methods that we find in Article 31. For example, this is evident if we look at the Costa Rica v. Nicaragua case of 2009, the FCJ, where the interpretative issue at hand concerned the interpretation of the term commerce, and in which the court clearly said that this term couldn't be seen as merely encompassing trade in goods, as it was when the treaty was concluded, because subsequent developments were to be taken into account, and therefore this term should encompass also tourism, for example, so the transport of persons. In this case, the court clearly relies on all the objective elements that we can find in Article 31. It starts from the wording, it places this wording into its context, for example, by referring to the other provisions of the same treaty, but also to referring to other provisions of other treaties related to the treaty that was at stake. It also takes into account subsequent agreements and subsequent practice of the states. It considers the treaty as a whole, and it reads this treaty in the light of its object and purpose. This very same approach can be found in every field of international law. In the field of human rights law, there are peculiarities, of course, because the court generally, and especially starting from the last 30 years, does not clearly refer to the ordinary meaning of the terms used into the treaty, does not explicitly refer to the ordinary meaning. I can see a straightforward trend to go to the solution immediately by mainly referring to other methods, like, for example, the object and the purpose of the treaty read in terms of principle of effectiveness, or to the principle of systemic integration. So I can't really see in the reasoning all the steps, but I have to say that these are implicit in the reasoning, that the court does not give enough justification to its interpretative methods. Notwithstanding this, I believe that behind the reasoning there's always Article 31. Even if, of course, there are peculiarities, the court refers to the need to interpret by taking into account present-day conditions, and sometimes, for example, as in the Mamatkulov case, when the court stated that the European Convention on Human Rights was a spatial convention, this might have led someone to believe that different interpretative criteria were to be applied to human rights treaties. I don't believe this. As regards case law of the arbitral tribunals, there is the Iron Rhine case, which is particularly important for my purposes. Of course, I cannot deal with the details of my research. I would like to refer to another case, the Kishanganga arbitration case, because in this case, Gabčíkov, Nažimares, and Iron Rhine were clearly referred to by the tribunal in order to conclude that, unlike in the treaties that were at stake in the Gabčíkov-Nažimares case and in the Iron Rhine case, in the Kishanganga arbitration case, the Indus Water Treaty of 1960 did not allow actually recourse to an evolutionary reading because its terms clearly limited the sources of law that were to be taken into account. Only the treaty in itself was to be taken into account in this case. And this case is also interesting because it raises the issue of the distinction between what is a mere interpretation and what, by contrast, is a modification of the treaty. Had the court adopted an evolutionary reading in such a case, this would have been a modification, the tribunal said. As regards the field of the case law of investment dispute tribunals, one of the cases that I find more interesting is the Mondev case, in which the standard of the fair and equitable treatment was interpreted evolutionarily, once again by referring to the methods laid down under Article 31 by taking into account the equal basis. The same applies to case law of the WTO bodies. In probably the most important example would be the Shrimp Total case, but I don't want to deal with this one. We just referred yesterday to the fact that that evolutionary reading was reached as regards the expression exhaustible natural resources. I find particularly interesting another case, which is certain information technology of 2010. In this case, the expression at issue was flat panel display devices, and the question was whether such an expression was to be considered as capable of encompassing also new technological devices emerged after the adoption of the treaty and that did not exist at the time the treaty was concluded. This case is interesting because it was said that actually the result reached by the panel was not an evolutionary one, because this result was reached by merely relying on the ordinary meaning of the terms. I disagree with this view. I believe that the panel applied the methods laid down under Article 31 with particular regard to the ordinary meaning of the terms, place, and its context, and so on. But I also believe that there's a confusion here between the method that had been applied and the result. The result, in my opinion, was an evolutionary one, notwithstanding what the panel was saying. And the same critics also apply to the separate opinions of Judge Guillaume and Skotnikov in the Costa Rica v. Nicaragua case, because there it was stated that the very same evolutionary reading could have been reached by simply relying on the ordinary meaning of the terms and by subsequent practice. The court relied on the ordinary meanings of the terms, and on subsequent practice, and the result was an evolutionary one. As a conclusion, I might say that dynamic treaty interpretation apply to every type of treaty. There is no distinction to be made in this regard. Of course, there are different shades. I think that evolutionary treaty interpretation is more frequent in certain cases, such as in the case of human rights treaties. And from this, we could also infer more general considerations and conclusions. I believe in particular that when in a treaty its contractual component is not the predominant one, in other words, when in a treaty it is more important the international regime that has been established, when in a treaty it is more important to pursue the general objectives that the treaty establishes, well, this treaty is capable of detaching itself from the will of the parties, and in such cases it will be more frequent and more suitable to reach dynamic readings, to adopt an evolutionary interpretation. This is clearly evidenced by the Gabčíkovo-Nažimaros case, because the interests that were at issue were not simply, as you said yesterday, were not simply the interests of the two states. Also, the interests of other states were at stake, but more generally, the interests of the entire humankind were at stake. When a treaty deals with erga omnes interests and considerations, it will be easier to have evolutionary readings in the end. Another thing must be considered. Evolutionary interpretation is for sure more frequent when treaties are meant to last, when treaties are intended to have a long duration, and this was the case of the Gabčíkovo-Nažimaros case, but also of the Costa Rica v Nicaragua case, and so on. Why this? Because if the treaty wants to survive, it has to be capable of adaptation to the changements that are naturally brought by the passage of time. I also believe that the formal way of treaty revision, especially in the field of multilateral treaties, are today, when a lot of contracting states are concerned, very difficult to reach. So, in my opinion, evolutionary treaty interpretation could also be seen as an answer to this problem that we actually face today. Thank you.
Many thanks, Irene, for your brilliant presentation. I think that several comments may be given on your thesis. I have some, but I should prefer to defer during the discussion, because otherwise there is the risk that I monopolize your time. But I'm particularly interested to these aspects that you mentioned in the end, that is the connection or the importance of dynamic interpretation in the case of treaties of longer duration. Therefore, there is a time approach, a time perspective. But I am particularly sensitive to the ecosystemic approach. So I think that also from the perspective of the subject matter of treaty, we can emphasize the importance of a dynamic interpretation. But in any way, I give the floor to now I say your name correctly, Panos. Panos. Termination of treaties. But before giving the floor, I would like to quote a passage by the concluding remarks of an article written by Malgosia Fitzmaurice for the Leiden Journal of International Law in 1998, because I find it very illuminating. I quote: "The court, obviously the ICJ in this case, unconditionally supported the principle of the stability of treaties. The ICJ has, by the judgment in the present case, strengthened the classical doctrine of the law of the treaties." Do you agree with this or not?
Thank you for putting me on the spot. I would answer, but I wouldn't want to give any spoilers for my presentation. So thanks for that segue in the introduction. First of all, let me in turn as well thank very much the organizers, Serena and Makan, for organizing this wonderful conference. Also for the participants, and most importantly, well, the participants didn't have any much choice in the matter, but the audience, particularly for waking up at 9 o'clock in the morning on such a lovely day, and especially coming from the Netherlands nowadays, I really do appreciate these days. So maybe next time a peripatetic kind of attitude in the conference. I have the pleasure to talk about the very chipper topic of how treaties die, basically. So termination of treaties. Now, one thing that was a major concern of mine, and this was due to the way that the arguments were presented before the ICJ, and also with respect to the various topics that will be analyzed, and taking also the cue, because every session needs to talk about the tango that John raised yesterday. I was a little bit afraid that I would step on people's toes with my presentation, in the sense that, as Serena will analyze in the next session, there are many connections between law, treaties, and state responsibility. So I put on the background tango-wise Astor Piazzolla, and try to find a way not to say things that would infringe on other people's presentations. I failed miserably, so I apologize in advance, and I will try to keep the overlap to as minimum as possible. If not, feel free to throw water or anything heavy at me as a kind of indication that I've gone too far. Now, before I begin, I'm going on a very long tangent here. A couple of issues, thoughts that color this particular presentation on termination of treaties. First of all, that the topic of the conference is the Gabčíkovo-Nagymaros judgment and its contribution to the development of international law. And yesterday in session number 2, there were these references to the development, and I'm in full agreement on multiple levels. First of all, because I think we all sometimes fall prey to, when we hear about the development, that we think of this as a kind of a linear, a very straightforward approach. And the textbooks, and also when we teach this, we have to give this impression that there is a plan, there is an end, there is a way forward. But in actuality, it's not such a linear process. It's much more chaotic, controversial, conflicting. It's like me trying to draw. It absolutely makes no sense. Also, that the idea of development can have multiple ways to understand it. It's not simply, it can be a landmark case, so a paradigm shifting case, or it can be a case where you expand on various notions, you develop a evolutive interpretation, you develop certain norms, or it can also be areas where you simply clarify an incremental contribution to the development of international law. And I think that this case is so important because it presents at various levels all these kinds of forms of development. And in the end, yes, it might not be a linear approach, but it's more kind of like pointillism, or as Reuter would say, a punctiform kind of approach, that you basically put dots, 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 and eventually, hopefully, a pattern emerges, or something that makes sense. The second one, the second thought is that another thing that is striking, and this was mentioned also in the first session by Stefan as well, when you discussed about the litigation strategy, is about the arguments, the way that they were proposed. So, especially with termination of treaties, it is surprising, and maybe Malgosia would say again that this is about the laziness of the either the judges or the people, the teams pleading the case. That there was sometimes a conflation between state responsibility and Serena. I'm not going to go into too much detail on that. But then the question is this really the case, or are we actually reading things into that because we've been conditioned since then to think in a particular manner? Because now we of course we have the Vienna Convention on the Law of Treaties, but also we have the 2001 articles on state responsibility. So we've kind of been conditioned to think in that particular way of being able to separate those two things. So maybe this is not so much the case that the arguments were pleaded in a bizarre kind of way, but that things have evolved, and we see that now as bizarre as a kind of temporal solipsism, that we think by modern standards. This is also the psychologists call this an Einstellung effect. That there's a fantastic experiment called the Lutyens experiment, which I always make my students be guinea pigs and do it. It's a water jug experiment. I don't know how many of you have seen Die Hard 3. Movie reference, absolutely. So the trick question about how to create a particular, anyway, just Google Lutyens, and Lutyens is a fantastic experiment to show how anybody, it doesn't matter what your level of education is, we are all very quickly, in 3-4 examples, conditioned to think in a particular manner. And then it becomes extremely difficult to break that particular pattern. The same thing here, with the connection between termination, law of treason, and state responsibility. Since then, we have been conditioned to think in a particular manner, but it's very difficult to break and start thinking with the way things were at that particular time. And having gone that long way, now finally it is time to actually talk about termination of treaties and what exactly the ICJ found in this particular case. Now, the first thing that is quite striking is that I will stop using the expressions famous paragraph. It's either all famous or all are famous, or then none of them is important. Fair enough. So in paragraph 99, the court, referring again to its analysis in paragraph 46, simply very quickly, in just a couple of sentences, said that the rules provided in the Vienna Convention on the Law of Treaties, specifically 60 to 62, are customary international law, and also that states in general were in broad agreement. So kind of as a secondary argument, just in case many people were not persuaded by this. And this is, Jean said yesterday that it's a tango between the ICJ and the ILC. I would say that the ICJ sometimes changes partners depending on what it suits it best. So in this particular case, they also tend to refer to the VCLT, because if they actually refer to the ILC and the discussions that had happened to the ILC, maybe they wouldn't have arrived at such an easy conclusion regarding the customary nature of these rules. But this is not something that is done for the first time. The ICJ does this almost consistently, and it relies on the VCLT and sometimes takes this approach. Another example, and now I'm stepping on Irene's toes here. In the Kazakili Sadudu Island, for instance, case, they quickly said that the rules of interpretation of customary international law, what they didn't actually refer to was that yes, now, but the treaty that they were interpreting was a treaty of the 19th century. So the question was, were the rules of interpretation at that particular point had the same content as they have today. So it is a very easy way, and it's understandable for reasons of judicial economy, for the court to actually gloss this over and saying, we apply the VCLT, it reflects customary international law, and now we can move on, rather than having to go through this entire process. Now, Hungary raised a number of issues with respect to termination. Basically, it was a textbook application of the VCLT. Pretty much almost all the major grounds for termination, so a material breach, fundamental change of circumstances, supervening impossibility of performance, with one exception, a very missed opportunity, big missed opportunity to claim, and I think Makan would smile if they had argued that that environmental rules were jus cogens. So the only ground, they would have failed, but they could have argued that. And the court actually does mention it at one point, that no party argued that this was jus cogens, and then moved on to next. So that was the only one that was missing. But even before they went to examine each and every specific of the grounds that Hungary raised, there was something that kind of flew under the radar. So in the main text, they said that the Article 60 to 62 of the VCLT were customary international law. Before they start their analysis, what they say is that the 1977 treaty did not have any particular article regulating withdrawal termination. So what do you do then? And the court simply said, well, the parties hadn't agreed, and also and let me find the relevance. It describes the treaty. The treaty establishes a long-standing and durable regime of joint investment and joint operation. That's it. Now, if one reads that, it would seem okay, makes sense. But if you consider that the rule that had to be applied was actually Article 56, or its customary law equivalent, then things again become a little bit tricky, because what the court does is, first of all, it says that the parties didn't agree, which is the first requirement under 56, paragraph 1a. But the second one, where they describe the treaty, is actually most likely an application of the second one, of the nature of the treaty requirement. And this is very, very interesting, because what it does is, first of all, it implies that they consider that Article 56 as well was customary international law. But if one looks at the preparatory work of Article 56, this was an area where huge debate had happened during the discussions of the ILC. Even Waldock in his reports wasn't able to satisfy everybody. He was criticized for being too progressive, and at the same time for being too timid in his structure of Article 56. Indicative of how debatable it was that even after the discussions in the ILC, when we switched to the Vienna Conference on the Law of Treaties, for this particular article, in the discussions there were 5 amendments to this particular article. And the version that they had was without the nature of the treaty, and this was inserted only because of the UK amendment. And that was the amendment that was accepted. Another interesting note, at least for me, because I'm a geek for law of treaties, is that Article 56 is the only article that uses the term nature of the treaty. Everywhere else, it's object and purpose, object or purpose, or so on. But this one is the only one that actually uses the term nature. Now, I'm not sure whether I don't think that it was intentional, that it was more the language and the last minute kind of insertion of the idea of the nature. But even the nature itself is problematic in the sense that the examples given for treaties allowing for denunciation, where commercial trading treaties, treaties of alliance, military cooperation, technical cooperation, and treaties of arbitration. And on the other side, treaties that by their nature do not allow for denunciation, boundary treaties, treaties affecting cession of territory, grant of rights over territory, an international regime over a particular area, territory, river, and so on. So it would seem that the court, by describing it as establishing a long-standing and durable regime of joint investment, probably goes for the second option, also by virtue, ex post facto, understanding that by the solution that they adopted. However, the analysis is a little bit that they mention it in just a couple of sentences, but there are many underlying presumptions in this particular solution that they adopted. And then they move on to the actual grounds with respect to termination. So the first one was supervening impossibility, and I will deal with these very briefly, just a few key points, because I'm realizing that I'm running extremely out of time. Supervening impossibility of performance, essentially the main concept is an object indispensable for the execution of the treaty. But then the question is, what do you understand by object? Because all of the examples that were given during the preparation of Article 61 were essentially physical objects, the submergence of an island. There was a proposal during the conference, and it's a pity that Greece didn't vote for it at that point. Now we're regretting it, that difficulty of payment due to dire financial situations was suggested as a ground for supervening impossibility of performance. Of course, it was rejected. But here the question is, in this particular case, the issue was whether, for the purposes of Article 61, we could also refer to a legal regime. And in the discussions, in the preparatory work of the VCLT, and again, I apologize for using the VCLT discussions, but I use this as a reflection. We all agreed that VCLT was not applicable, but this indicates the status quo of the law at the time. They avoided answering it. Waldock in his report had expressly rejected this idea, referring to natural and physical objects. And the court simply says, I don't have to deal with this particular topic on whether it is a legal object or not, because in any event, Hungary had acted in a way that disallowed it from actually invoking Article 61. In a similar fashion, with respect to material breach, firstly, and Stefan also raised this yesterday, Hungary had tried to invoke violations of other obligations in the context of material breach. The court simply said, no, this is not an issue. It has to be a violation of that particular treaty. Now, in paragraph 108, the critical point was what some authors have argued as a premature breach. That basically, whereas variant C came into effect in October 1992, Hungary had made the notification regarding the termination in 19 of May 1992. Although Hungary had argued that the actions of Slovakia essentially were part and parcel, that the violation had started earlier, the court was not satisfied by this, and they basically claimed that they had acted before a breach had actually occurred. You could try and make some nice arguments then about preemptive or preventive material breach, but I think that would be taking it too far. Maybe for an article, perhaps. Lex ferenda kind of thing. But also, again, and this shows also the connection that the ICJ shows with previous jurisprudence. It again repeated the findings in, and I mispronounce this all the time, Khrushchev. You see how many people? Factory at. What is this case? Khrushchev. Okay, so now you've heard it. It's on screen. This is the way you pronounce it. You can say it in English, chorzo. So it repeated once again the finding there that Hungary could not, in any event, invoke an alleged material breach on the part of Slovakia, because they themselves, through their own actions, had contributed to this particular situation. With respect to material breach, I actually find the procedural requirements quite interesting, because in paragraph 109, the court goes into a discussion about the time between the actual declaration regarding termination of the treaty and when they said that it would enter into effect, and it was 19 of May 1992, and the effect should take on the 25th of May 1992, so 6 days. So the court there does not take a position on whether Article 65 to 67 of the VCLT are customary international law. They simply go about it in a circuitous manner, saying that if they don't codify customary international law, they generally reflect customary international law and contain certain procedural principles which are based on an obligation to act in good faith. Basically, they don't take a position on the matter, whether it is customary international law or not, but they simply say, well, 6 days clearly is not enough under any understanding of good faith. And then we go to the fundamental change of circumstances, and very briefly, they focused a lot on the negative wording of the article in the VCLT to show the exceptional nature of fundamental change of circumstances. And the critical point was the argument about socialist integration that the treaty was supposed to be a vehicle of. The ICJ said that the prevailing political conditions were not closely connected to the object and purpose of the treaty. So it didn't come out right and say that changes in political circumstances are never fundamental change of circumstances. They left open that kind of possibility. But in order for one to invoke, a lot of other elements had to be satisfied. So it had to be closely connected to the object and purpose of the treaty, and it would have to radically transform the obligations. Just half a year later, the European Court of Justice in the Rakhine Corporation versus Haptalat Mines actually made that, but that was done in a completely different context with the dissolution of Yugoslavia. And essentially the argument there was that the basis of the consent was that there would be effective institutions that would actually be able to effectively ensure the operation of the treaty. So with the dissolution of Yugoslavia, that was not possible. So there was a degree of magnitude, but it shows the gradual evolution from Gabčíkovo and Nagymaros, and just within 6 months, and to the ECJ's credit, they actually referred to the Gabčíkovo Nagymaros case in their judgment. So very quickly, because I know I'm running out, so just a couple of more minutes. Another thing, also in paragraph 114, the court very quickly and not in a very explicit manner kind of hints at the idea of in adiplendi non est adiplentum. I think Serena will analyze this in more detail, or maybe I'm throwing you under the bus here. I'm sorry. Okay, so okay, fair enough. Fair enough. So in that paragraph, the idea was that the court said, first of all, it rejected the idea of reciprocal violation of the treaty in the context of that principle. As a ground for termination of treaties. So they simply said that this does not apply for termination of treaties. This might leave the possibility about suspension of treaties, although that making that kind of separation might be a little bit difficult. Yet nonetheless, the same argument was presented by Greece in the interim accord case, Ferrara versus Greece, again to no success. But it is interesting to see that the court, at least in one paragraph, very quickly referred to this idea, and in rejecting it, is, as the Madam Chairperson mentioned at the beginning, repeated again the idea of stability of international relations. They felt that if they allowed for this kind of scenario, this would be extremely problematic, and this concept, this idea about the interplay between flexibility on the one hand and stability of international relations was permeated the entirety of the discussion of the ICJ with respect to termination of treaties. So in conclusion, with respect to the development, the contribution of the Gabčíkovo and Nagymaros case to the development of international law as to what termination of treaties is concerned, there were some areas where they went a little bit forward, some underlying implications there. But again, I need to repeat that development does not have to be a paradigm shift. It can be, as the mathematicians call, an incremental evolution, or as Newton said, actually stole from an unknown source from the 14th or 15th century. The reason why I can see further than the others is because I'm standing on the shoulders of giants. And in the case of the ICJ, well, the ICJ would like to say that they themselves are the giants. But it is also the progression of cases. So not all cases push everything forward, but everything also allows for the clarification. And with this, and I'm too immature to resist the temptation to make a pun, with this I terminate my presentation.
Panos, many thanks for your very brilliant presentation. I should say twist and shout style. It's okay, because we passed from tango to rock and roll and now to twist style. Yes, a lot of thoughts, a lot of remarks. May I simply say I'm rather skeptical about the possibility of certain written rules that contain procedural, very strict procedural requirements to be transformed in a customary rule. Is it possible? Is it really possible or not? Because I'm rather skeptical on that. In principle, yes, when we have a general conduct, a general behavior, so it is rather simple to recognize in a written rule its customary nature. But when we have a very strict procedural requirements, I have some doubts.
Should I, or is it for both?
For both, yes.
Or should I?
Well, really, I don't think that there should be a distinction. Actually, I'm not too keen into the distinction one. I don't know. What do you think?
Well, I always like to answer a question with a question. So could you give me a definition of what you mean by procedural rules? So, I mean, the argument is, and John makes that argument, that rules of interpretation are also procedural rules.
Yes, actually, I referred to, for instance, Article 57, because you guessed that maybe the ICJ didn't explicitly mention that this is a customary rule, but there are so many paragraphs, subparagraphs, conditions, requirements, and for instance, a temporal requirement, 6 months, 3 months, and so on.
Yeah.
So I have some doubt.
No, sorry. Yeah, I think that, and Irene has said that you cannot distinguish because, and the same thing is that if I manage to prove that certain procedural rules are customary international law, then the onus probandi is on you to prove why these particular ones are not open to being customary international law. But then again, I go back to the definition. But with respect to this, I completely understand the very specific requirements, and I think that's why the ICJ said, even if they're not customary, they reflect customary international law. So there is a core of settled practice and opinion juris on that particular matter. It might be very vague, very chaotic, but that is for pretty much every rule. So there is a penumbra of uncertainty always. And I think, for instance, the ICJ has done this about the effect that things have, also in the context of optional clause declarations, which is not customary international law, but it shows the permeation of a kind of idea that goes through all those rules about when an optional clause declaration produces effects, when it is submitted and when it is withdrawn. And it has taken a different solution to these two based on reasons of equity, fairness, equality of arms, and those kind of things. So I think that's the idea that maybe not to such precision as in the VCLT, but at least a form of its content can be allowed to have a customary nature.
I'm satisfied. Thank you. Questions to our speakers? Thank you, Margosha. You have the floor, yes?
Thank you very much. I have some comments for speakers. So maybe, Irena, thank you very much. It was really very illuminating. However, I have doubts whether the court in Gabčíkovo case applied evolutionary interpretation. In fact, in the judgment, the court relied on this, I think, Articles 19 and 20 of the agreement, which included the clause that the states meet from time to time and review the treaty in order to, change the terms of the treaty along with the changing circumstances. So it was inbuilt in the treaty, this possibility of changing the terms. I don't think that the court actually thought in terms of evolutionary interpretation. This kind of interpretation became fashionable a little bit later. And in fact, I talked to Professor Skubiszewski, who was an ad hoc judge in the case, and he never mentioned it. He actually pointed out to me that the court fully relied on these articles of the treaty to give the chance to the parties to reflect more on the changing circumstances, but not as an evolutionary interpretation. Mm-hmm. I think that we sort of try to read maybe a bit too much in on this evolutionary interpretation. We see it everywhere now, but I think that also as you pointed out very rightly, Judge Skotnikov, is a very fine line between subsequent practice, evolutionary interpretation, modification of the treaty, and sometimes it's very difficult to tease out with clear sort of view what is what, I think. And even attempts to do it, I don't think we should be too clear about it. Also, I would like to mention that in my view, what the European Court of Human Rights is doing is totally different evolutionary interpretation from other evolutionary interpretations, because it also has moral background. The court moved several times from the assessment of what it is doing in interpreting the convention from convention as a living instrument, from the Tire case to sort of common grounds, morality, etc. So I think it's a different type of evolutionary interpretation, and putting this into one bag is not a right thing, I think. I think that we can. It's really like, I hate this sui generis. Everything is also sui generis, but it's a different type of interpretation. Now, so this is my comment to you. And now articles, procedural articles 65, 66. I think there is some movement to acknowledge them as customary law in the arbitration between Croatia and Slovenia. It was already assumed, the arbitral tribunal said that probably Article 65 and 6 are customary international law. So I think it's a certain movement to changing the status of these articles, even from the Genocide Convention, Congo-Rwanda, when the court said that they are not customary law. So I think it's already some change in the assessment in international law of the status of these articles. Thank you.
Thank you very much, Professor.
Okay. Maybe we can collect some other questions. Please, Makan.
Yeah, thank you very much, Laura. And thank you very much to both Irene and Panos for great presentations. I really enjoyed them. Santiago Villalpando should have been here, but he couldn't make it because he's in Bangkok right now, I think, for some UN meetings. And he's the one who's supposed to write a contribution on Pacta Sunt Servanda in the forthcoming book on this judgment. And I've been wondering, because I think that one as a contribution of the Gavshikovo-Najimaro judgment is on how the court has interpreted Pacta Sunt Servanda. The court came for the first time with a very exhaustive interpretation of what is Pacta Sunt Servanda, that Pacta Sunt Servanda goes beyond the intent of the parties, it even goes beyond the text, and what matters is that the parties by any means necessary fulfill the object and purpose of the treaty. So I've been wondering whether you guys have thought about how Pacta Sunt Servanda in this case has kind of, influenced the interpretation of the 1977 treaty by the court, but also the issue of termination, how the court has been dealing with termination, because the court talks about it, but then doesn't come back in detail. But I think that behind the reasoning of the court regarding interpretation and termination, Pacta Sunt Servanda, and the way the court has interpreted it has been quite influential. Thank you.
Is there a question, please? Oh, sorry.
Sorry, I just excuse me. Okay. Sorry about that. Yeah, it's a question for Panos. A few years ago, I had to work on Article 61 of the Vienna Convention, which were for the commentary by Klein and Corten, and it was not an easy task. It was very interesting. I must say that at that time I was, I think, puzzled is the right word for the interpretation of the case. So my question is, isn't it a missed opportunity for the court to have dealt with Article 61 in the judgment? Let me just very briefly explain the situation. On the positive side, seems to me that, as you have mentioned, the court managed to how do you say that in English? To resuscitate Article 61, which was really, when it is only linked to the physical, the disappearance of the physical object, seems almost impossible to apply. So it gave some relevance to it, and at the same time, and this is my question, I may be completely wrong. In my view, I was reading the case again for this conference, and as far as Article 61 is concerned, seems to me that the court used it more to circumscribe the notion of force majeure as distinct from Article 61 than to take Article 61 seriously, if you want. So this is my missed opportunity question, but again, it's a very open question.
Before we just give up the mic, no, just a very quick note. To me, if I remember correctly, there was an arbitration case between Swiss and Austria, which preceded the entry into force of the Vienna Convention between these two countries. And even then, the two countries agreed that the rules 65-68 of the Vienna Convention, if not binding in their precise terms, were, however, to be followed as, I can't remember the precise word, but to me this was an important evidence that really there was an extended feeling that there was to be some procedural good faith obligation before you could invoke a ground for termination, for example, of the treaty. So it actually goes back before the judgment of the court. And I would say that it's the normal case that if you have a codification convention, that convention will inspire states to say something or not about those. So I wouldn't think that, of course, we cannot have the 3 months, the 1 year, but the idea which was transposed to the procedural conditions to adopt countermeasures, the idea that there must be some dialogue between the parties before one resorts to termination in one case or countermeasures in the other is really does have a broad basis already. Thank you. Alessandra. The left side.
Send the mic to Slovakia.
Thank you very much. I could say that everything's already been said, but not by me. First of all, again, also from my side, thank you very much. It was not just interesting presentations, but really I enjoyed them very much. And I would have liked to continue listening to you longer. Now, as to Irene, for once I have to say, I share the view of Margosha. Actually, I have this. Yeah, that's self-defense. No, I have similar, actually, the same doubts whether the court really applied, whether it intended or not, we will never know, but whether it really applied the principle of evolutionary or dynamic, whatever you call it, interpretation. And I was wondering, I mean, you referred to the subsequent practice, right? But and I'm not quite sure because I didn't read the case against the background of interpretation or reread the case. But the paragraphs where it presumably, and that's I think what you also quoted, paragraph 132 actually, yes, where it deals with sort of subsequent practice, but most of that is not subsequent practice in the meaning of Article 31, because it is. First of all, I wouldn't say it's subsequent practice in the application of the treaty. First of all, it's mostly subsequent practice in the non-application or in the breach or in the non-implement, whatever. And secondly, not of both parties. So these are certainly two problems which prevent a sort of recourse or resort to subsequent practice in the context of Article 31. And I would also say that evolutionary interpretation, as within the meaning of the practice of the European Court of Human Rights, it's not evolutionary; it's almost revolutionary. What the European Court of Human Rights here does. But that's not meant to be a criticism. But it's of course an issue of legal policy. Now turning to Panos, I was never aware of the fact. Well, I came across it when rereading the case, Article 56 of the Vienna Convention on Treaties, but I was never aware of that. That the court made a very clear statement on that, and I have to say I'm very thankful for that, because I'm totally convinced by the court's reasoning that the 1977 treaty is one that comes within the meaning of Article 56, paragraph 2, and it is always you have those extradition treaties, you have the military alliance treaties, and the SOFAs, etc. Well, these are obvious cases, and then you have the boundary treaties where the opposite would apply. And I think you can make an argument out of it, but I think it's very convincing that according to the nature of the treaty, the 1977 treaty, it's not one subject to termination without an explicit provision to that effect. So I'm very thankful for the court on that. And I think when Article 56 speaks of nature, and you made that again something I never was aware of. It's a good point that you make, the distinction between why nature, not object and purpose, where everywhere else in the Vienna Convention, the convention speaks of object and purpose. Good. An interesting point to really think about. Is it a deliberate one? You said that the travaux are not very illuminating on that. But
I can answer.
Sure. I hope so. I would think that the nature here really refers much more than object and purpose to the subject matter of the treaty itself, which is, I think, in most cases easier to be determined than object and purpose, where you can read anything into it, what you want to have to read out of it. And then one short remark to Article 62. Here, I don't know whether this was sort of but it was just a sort of Freudian slip that you made. But Article 62 doesn't speak of object and purpose. You mentioned it, but I think again this is very important because the point here is whether these circumstances were the basis for the consent to be given to the treaty, actually irrespective of the object and purpose of the treaty. Again, you would have, but here it's made clear in Article 2, I think it's the exception to boundary treaties, which again is not so much an issue of object and purpose, but rather the nature, the specific nature of the treaty. Yeah, and on just one, couldn't resist. ICJ is about, standing on the shoulder of giants, and the ICJ itself. The ICJ is not the giant; it's the Olymp.
Yes. Do you want? Two questions, one for Irene. Well, I don't know actually if perhaps it is right that the court in Gabčíkovo did not have recourse to evolutive interpretation, but in my view, at least the court strongly invited the party to apply the treaty in an evolutive manner, and that is very close to treaty interpretation to my mind. But having said that, there is one point in Irene's presentation that struck me. It seems, but tell me if I got it wrong, that you are convinced that the ICJ, when it applies evolutive interpretation, when it has recourse to evolutive interpretations, normally relies on Article 31 of the Vienna Convention, which in my view is not exactly true, because, for instance, in the navigational rights, the court, yes, paid lip service to Article 31 and 32, but then, in order to justify the evolutive interpretation of the word comercio, commerce, it relied on the idea of this is a generic word, the treaty, and it seems to me that the court says it can be presumed that it was the intention of the parties, that this term is evolutive. There is nothing in the Vienna Convention, in my view, Article 31, that can support this kind of approach. And this is not new. I mean, this is the approach the court followed in the Namibia case. It is the approach the court followed in the Asian continental shelf case. We can try to rely on the Vienna Convention and try to say, well, this is the ordinary meaning of a term. This is Article 31, paragraph 3c. even if in the case of commercial, the court did not mention the evolution of the law. It didn't say there is an evolution of the law to justify an evolution of interpretation of the meaning. We can say, but my impression is that the court always, particularly when it has to address an evolutive interpretation of a treaty, try to demonstrate this is really the intention of the party. And the fact that they used a generic term, which in my view it doesn't mean anything. What is a generic term? Everything is generic. But this means that it has to be interpreted in a generic way. So just to, if you can develop your argument about why the court, for instance, in the navigational right case relied on Article 31 to explain the evolution. For Panos, I have a question which does not relate, I'm sorry, to termination of treaty, but on the determination of customary international law. And I think perhaps a presentation on this would be very helpful in our panel. Why? Because yesterday Jean was impressed by the court reliance on the ILC works. I must say that I'm even more impressed by the fact that in this case the court always rely on the agreement of the parties. And you underline it in your presentation. Particularly with regard to Article 60, 61, 62, it says there is a Vienna Convention, but there is also the agreement of the parties. My question is, and so what? If there is the agreement of the parties, is it of any relevance for the determination of customary international law? I mean, I can understand it if it is an interpretation of a bilateral treaty by the court. There is the agreement of the party, okay, no problem of interpretation. But if there is the agreement of the party and the court has to determine customary international law, is it of any relevance, I mean, for the legal reasoning of the court?
So many thanks. Oh, yes, please.
Just 2 remarks. Thanks for your presentation. I just would like to come to Paolo's observation because the court, International Court of Justice, does not rely on Article 31 in order to justify evolutionary interpretation of treaties, and refers to generic terms or these concepts, vague concepts. And the same goes for the European Court of Human Rights, because also the European Court of Human Rights simply refers to this concept of the living instrument. No? The European Convention is a living instrument, so it does not really find, how to say, a very technical or specific rule into the Vienna Convention to justify evolutionary interpretation. That say, I just wanted to ask to Panos to elaborate to this concept, because he referred to the non-existence of a paradigm shift in the jurisprudence, the evolution of the law, but you say that this is always incremental. And I can agree to this, but it seems to me that sometimes we have paradigm shifts in the evolution of law, in the evolution of international law. And it came to my mind when you referred to this incremental or paradigm shift dualism. It came to my mind the Marshall Islands case, where actually you had a paradigm shift. Okay, it was, let's say, incremental then, because there were some cases before where the court actually, it doesn't, it does not have anything to do with determination of treaty. I'm just talking about, in general, the evolution of international law. But in the Marshall Islands case, I see a paradigm shift when court find that in order to a dispute to exist, the party must be aware of that dispute. I just wanted to ask you what you think about this. Thank you.
Two last short remarks by Malgosia and Attila.
A short and quick reaction to Paolo's statement. As much as I very much side with your approach concerning the evolutive interpretation, and I will then react perhaps in the conclusion to Malgosia's and Stefan's comments to Irene's presentation on evolutive interpretation. But just one question about why the court, after stating about the custom, and I'm speaking also under the control of Makan, and this is a joint statement, is that, why did the court, after having stated about the customary nature of a given rule by the Vienna Convention or treaties, take the trouble to emphasize that both parties agreed? Why was it that the court felt it need to do so? And if you take the Nicaragua case, it was the other way around. But the situation about the applicable law was absolutely, and the function, the administration of justice function was absolutely different. The court, as much as we scholars would want the court to state the law, the state of the law generally, there the court, particularly under the special agreement circumstances, was to settle the dispute. So they had to be satisfied that there was agreement by the parties about the applicable law. In the Nicaragua case, the court did the contrary, the reverse, and very much consistently. First, it looked at the attitude of the parties, they consent with respect to this or that international piece of treaty law, and then it said, but then I have to be content, cannot be content with this, I have to see what is the general conventional practice, and see the general practice, the general opinion juris, and went to affirm the state of customary law. But it did not just, because there it was very laborious, and here it was very lazy, because there he had to prove the jurisdictional basis that he had in applying customary law. So let's not lose sight of the fact that in this case the court had to focus on the consent of the parties for purposes of the basis for the applicable law. That is, I think, the reason why it looked at the state of customary law, but then it had to be 100% sure that obviously customary law would bind also these parties because it is by definition general, but the applicable law here was treaty law. So the consent was key for the court to apply that law.
I append a strong dissent.
But then also I think that in addition to what Attila said, I think also, Paolo, there is the all judicial comfort idea. If the court can say that the two parties also agree to the applicability of a rule, the court would say so to feel comfortable. This is just judicial comfort. Judicial economy. No, I call that judicial comfort.
The question is, are the limits to that? What if the two parties agree on a rule of custom which obviously is not? Is that possible? Is that subject to review?
What is the audience of the court? The two parties just or the entire world? I mean, who is the court?
The two parties.
The two parties.
The court is there to settle the dispute. 38 of the court is there to settle the dispute.
It is an arbitral tribunal, not the court.
Yeah, okay.
Final remark,
Yeah,
yes, please.
thank you very much. I would like also to add that I think the court became more careful from the Namibia cases in sort of progressive interpretation, let's not put it evolutionary, of treaty. In whaling case, it's a very good case to point out that the court really, despite pleadings of Australia and New Zealand, really didn't ignore totally the idea of changing approaches to whaling, which would influence the interpretation of the whaling convention. In fact, the court said in a famous paragraph, I think 57, that object and purpose of the treaty cannot change through interpretation or practice of states. When Australia and New Zealand try to plead that there are two main objectives, ecological and then orderly administration of whaling industry, and the second object and purpose of the treaty basically stop having any relevance. And the court said, no, we can't, the object and purpose cannot be changed through interpretation. So I suppose evolutionary interpretation we may add mentally, or practice of state. So I don't think the court is so very inclined to apply at least ICJ evolutionary interpretation to treaties. In fact, court is very cautious, and I think in 1997, I don't think the court really relied on evolutionary interpretation, just these paragraphs of the treaty which allowed, from time to time review of the treaty provisions. Thank you.
Next workshop on the Whaley case. Evolutionary interpretation in the Whaley case. Next workshop. Yeah, I propose. So, Irene first.
Thank you for your very interesting comments. I think that the court reached an evolutionary reading and then invited the parties to take into account this evolutionary reading because the court knows where the boundaries between interpretation and revision of the treaty are. And so it was a kind of natural consequence to refer to the parties for the negotiation on the basis of the reading that it had adopted in the case. And in the separate opinion, Judge Bejawi clearly refers to the principle of evolutionary interpretation. I don't like this expression because what I really believe is that evolutionary interpretation is a mere result that derives from the normal application of the general rules on treaty interpretation. And as regards the point of these vague terms, in the light of which we can extrapolate the intention of the parties, to say that the term is vague, we have to look at the wording of the treaty, to place this wording, to try to give to this wording its ordinary meaning, to place the wording in its context, and then at this point we can say that the term is vague. But in my opinion, the reference to the intention of the parties that must be intended in an objective way because it is based on Article 31. And Article 31 is a rule that clearly adopts an objective approach to treaty interpretation. I believe that the reference to the intention of the parties is a fictio iuris that the court has used actually in order to justify the reading, which is based on Article 31, on the application of the criteria of Article 31. As regards the case law of the European Court of Human Rights, I believe that the peculiarities of the treaty are linked to the preamble to the European Convention, because the preamble in itself makes reference to the need to further realize human treaties. And I think that this has a great importance then in the interpretation of the treaties, of the treaty in terms of a kind of interpretation which clearly over-relies on the object and purpose, but this is normal when in consideration of the nature of the treaty at hand, I think. Macan, I also think that in this case there's a strict link between pacta sunt servanda and treaty interpretation, and actually I've referred to this paragraph when I've said that, in my opinion, the court perceives the text as the starting point. These words have been used by the court with reference to the pacta sunt servanda principle. I believe that since interpretation and application, the borders between interpretation and application are blurred, it is difficult to distinguish. I believe that what the court said, referring to pacta sunt servanda and relying on the basis of the principle of pacta sunt servanda, which is the good faith principle, must be transposed into the interpretative reasoning, that we may create a parallelism between the two. I think I'm done.
But I'm not coming back to the dissenting opinion. Yes, sorry. I'm not coming back to your dissenting opinion on the court's judicial function, but the fact that a treaty has to be interpreted in good faith under Article 31. Is it not intent? No? Okay.
It doesn't say if you have to interpret at the time when the treaty was concluded or at the time when you have to interpret. I mean, it doesn't say much, Article 31, about evolutive interpretation.
But intent, you were saying that you don't see where intent is in 31.
No, where is the intent hidden?
Good faith. Good faith.
In many places.
There are many things.
Yeah. Which could include intent. No. I just wanted to jump in
Bring us back on track.
No, not at all. I'm always in favor of chaos. I'm sure I'm going to miss a few of the remarks because, as you can see, it was not a joke. My notes are absolutely horrendous. So I'll try and answer to as many. First of all, with the comment by Malgosia, the Croatia versus Slovenia, which was, apart from that, first of all, it was a very interesting case on material breach. Regardless of whether you agree or not with the final conclusion. It also examined multiple objects and purposes in that. So it examined 2 objects and purposes in that particular case. With respect to Makan, first of all, absolutely love that you use the term interpret the principle of pacta sunt servanda, because this goes to a discussion that we had about whether you can interpret principles or customary international law, not just written text, which finds me in complete agreement. And I think I echo Irene on this one, that it kind of permeates the entirety of the judgment of the court. You can see that also with the approximate application analysis. So the idea was to understand the pactum in a kind of variety of manners, and this permeated both interpretation, termination, and even reference to various general principles. With respect to peers, whether it was a missed opportunity, depends on who you ask. If you ask an academic, yes, but the ICJ is notorious for missing opportunities. Marshall Islands being one of them. Never forget. Yeah, more recent one. There are many in between. But your comment about the mixing the concepts and ideas behind force majeure and the supervening impossibility of performance, I think is right to the point. And this goes again to the discussion that now we may be conditioned to have this kind of discussion. But at that time, when they were discussing, especially the Vienna Convention on the Law of Treaties, these were a little bit mixed. And you can see that also in the discussions, that arguments from state responsibility jump back and forth between law of treaties and state responsibility. So I do agree as an academic that it's a missed opportunity. As a judge, I think I completely understand them, that it was much easier to sidestep that issue through a much easier path rather than having to explain in much more detail and in a much more debatable fashion, because that would be a third presentation here today about the supervening impossibility of performance. Alessandra, I agree with everything, so there's nothing there. That indeed procedural, there can be customary rules with respect to procedure. Stefan, with respect to nature, I think I'd have to double check again the preparatory for that, both at the ILC and at the Vienna conference. My feeling is that this might be a little bit of a combination of both. If you look at the discussions, also at the Institut de Droit International, they really like to focus on the nature of the treaty, especially when they were creating exceptions. So they really always found that term as a particular fallback. If it was intentional, the selection of the word nature, I agree with you that it has a different content than object and purpose. There is a problem there, however, that this idea of nature also might lead to certain presumptions that I'm not quite comfortable with, because you see that also with evolutive interpretation. A lot of the times they refer to the nature of the treaty and that it is automatically interpreted evolutively, which finds me in complete disagreement there. With respect to the Freudian slip, it wasn't a Freudian slip, but perhaps I didn't finish the quote because in paragraph 104, it says, in the court's view, the prevalent political conditions were thus not so closely linked to the object and purpose of the treaty. They do say that they constituted an essential basis of the consent. Yeah, so they kind of bring in the object and purpose in a bizarre kind of fashion. But that was the direct quote, and that's why I referred to the object and purpose. Whether they're Olympus or not, Malgosia would always, when I was writing my PhD, would always strike out references to Greek Gordian knots, although she mentioned it yesterday. So Olympus, Stefan mentioned it, not me. With respect to Paolo's comments, about the ILC, whether they refer to the ILC or not, depending sometimes. They sometimes consider it as preparatory, and the ILC itself said it, so it is a little bit bizarre there, that they consider their own discussions as preparatory work of the second order. I think De Luna made that comment, which I found fantastic, in order to say it should be used all the time. Whether why the court referred to, and here I think I append partly concurring and partly dissenting opinion to the debate. I think that the reason I find the argument made by Makan persuasive, that it was more about judicial comfort as a kind of a safety net there. It felt a little bit bizarre. It felt a little bit technical in the structure, the way it was worded. To me, the impression was that this was something that was debated a lot, and this was a kind of a compromising language that they found in order to get away from it. Whether it is customary international law or not, or whether you can have, well, yes, you can, because even the rules of interpretation are residual in nature. So if the parties agree to have different rules of interpretation, that's fine. But whether you could have a bilateral customary law, and definitely not just on an ad hoc agreement, no. But I think the court didn't focus on that much. It felt that there was a nucleus of settled practice on this particular topic, and the agreement of the parties was a kind of a cherry on top for them. I think that was the way it was structured. And finally, with the final comment about the Marshall Islands, as I told you yesterday, that case made me lose a bet and a bottle of scotch to a colleague of mine on why it would be rejected, which hurts me very much. But perhaps I didn't express myself quite clear. I said that in the case of termination of treaties and Gabčíkovo-Nagymaros in particular, the development was more in the incremental fashion. Not that paradigm shifts don't happen. You always have the landmark cases or the shifts between, so you have the Lotus principle, then the reversal, then the Kosovo advisory opinion. So you have all of these. But in the context of the topic that I was presenting, I said that I felt that what the court did was not to go in a completely new direction. It focused a lot on the Vienna Convention on the Law of Treaties, on the discussions of the ILC. Well, not so much on the discussions of the ILC, but that it clarified, it elaborated on a few concepts, either explicitly or indirectly with certain of its presumptions. So in that particular section, I felt that it was incremental, not generally with respect to the ICJ. And I don't know if I've forgotten anybody, but I apologize if I haven't. And during the break, because I think we need to have a break, we can discuss this.
So thank you so much for this comprehensive discussion, for your exhaustive presentation and replies. Can we enjoy our fundamental right to coffee break? Okay, thank you. Thank you.
And I do completely agree with you on this. The point of interpretation is simply you look at the text. You don't take any presumption just because you know